Hi every friends, welcome back to the series of videos going through AIA B101 2017 contract, and we're doing this for the purpose of helping you with your studying for the ARBs. With last video we finished Article 7, so here I have printed what we have left. So we're going to start with Article 8 and go through Article 10. So without further ado, let's get to it. Article 8, Claims and Disputes. 8.1, General. 8.1.1, the owner and architect shall commence all claims and causes of action against the other and arising out of or related to this agreement, whether in contract, tort, or otherwise in accordance with the requirements of the binding dispute resolution method selected in this agreement and within the period specified by applicable law. But in any case, not more than 10 years after the date of substantial completion of the work. So this is a pretty lengthy sentence, but essentially what it says is that anything you want to do against the other party, you have 10 years to do that, essentially. Anything after that is too bad. The owner and contract waive all claims and causes of action not commenced in accordance with this section 8.1.1. 8.1.2. To the extent damages are covered by property insurance, the owner and architect waive all rights against each other and against the contractors, consultants, agents, and employees of the other for damages, except such right as they may have to the proceeds of such insurance as set forth in AIA Document 8201, 2017, General Conditions of the Contract for Construction. The owner or the architect, as appropriate, shall require of the contractors, consultants, agents, and employees of any of them similar waivers in favor of the other parties enumerated herein. So what this is saying is that if insurance pays for the damage, then you're not going to be going at each other. That's pretty much it. So if the owner wants to make a claim against the architect for a leaky window that insurance has covered already, there isn't really a whole lot that can be done there. Property insurance, yeah. 8.1.3. The architect and owner waive consequential damages for claims, disputes, or other matters in question arising out of relating to this agreement. This mutual waiver is applicable without limitation to all consequential damages due to either party's termination of this agreement, except as specifically provided in section 9.7. We'll get to that. But for now, we want to be really familiar with the term consequential damages. What this means is that one of the very basic examples that I hear people use to describe what consequential damage is imagine you have a piece of expensive furniture or expensive artwork or something, and due to failure in construction or your architect's detailing, let's say your roof is leaking or there's something wrong with the ceiling and your expensive piece of furniture or artwork is rendered useless and destroyed. So you as the owner, you're so upset and you're thinking, well, this is because the architect failed to detail this correctly. And then if you as the owner go to the architect is going to tell you, no, it's not my fault. It's contractor's fault because they didn't do a good job constructing this. So what this paragraph here is saying is that if this happens to you, that your expensive piece of furniture gets destroyed because of a leaky roof or something, too bad. You can't really go after the architect. So it's very telling that this paragraph is in the AIA contract. And we had already talked about this, that AIA tends to protect architects. So if you are dealing with the non-AIA contract, chances are that this paragraph won't be in it. Because when the owner pushes onto you their own contract, obviously they're going to try to protect themselves, and they will insist on not waiving these consequential damages. But for the purpose of your ARE examination, you are responsible for studying the AIA contracts, so that's what you get. Okay, 8.2, mediation. 8.2.1, any claim, dispute, or other matter in question arising out of or related to this agreement shall be subject to mediation as a condition precedent to binding dispute resolution. If such matter relates to or is the subject of a lien arising out of the architect's services, the architect may proceed in accordance with applicable law to comply with the lien notice or filing deadlines prior to resolution of the matter by mediation or by binding dispute resolution. So in your studying, it's pretty important to understand what binding dispute resolution is. Essentially, you have a dispute, means there is a disagreement and you are looking to get paid, or there is a disagreement about it, whatever, right? And then if it says binding, that means that whoever brings the decision regarding your dispute, that decision is final and you can't dispute it. Okay, 8.2.2. The owner and architect shall endeavor to resolve claims, disputes, and other matters in question between them by mediation, which, unless the parties mutually agree otherwise, shall be administrated by the American Arbitration Association in accordance with its construction industry mediation procedures in effect on the date of this agreement. A request for mediation shall be made in writing, delivered to the other party to this agreement, and filed with the person or entity administrating the mediation. The request may be made concurrently with the filing of a complaint or other appropriate demand for binding dispute resolution, but in such event, mediation shall proceed in advance of binding dispute resolution proceedings, which shall be stayed pending mediation for a period of 60 days from the date of filing, unless stayed for a longer period by agreement of the parties or court order. If an arbitration proceeding is stayed pursuant to this section, the parties may nonetheless proceed to the selection of the arbitrators and agree upon a schedule for later proceedings. So this paragraph says a lot, but there are a couple of takeaways here. One is that you should always start to solve your disputes by mediation. And mediation is essentially a process in which two parties that are in this dispute, disagreement, claim, they are looking for a neutral third party to help them come to a conclusion or come to a solution, essentially, of their claim. Oftentimes, architect will take on that role which in some situations can be fairly tricky, and I would recommend that you listen to Schiff Harden's lectures on this, where he explains how if an architect is in a situation to mediate between contractor and the owner, imagine, like, if you're a contractor, you know that the owner is paying the architect and they have an agreement, the B101, and contractor has nothing with the architect. So contractor can immediately be very unhappy with that setting. So a lot of times contractor will insist that architect does not serve as a mediator. And then this paragraph also says that you can pursue mediation and, let's say, arbitration at the same time. However, mediation should take precedent, and it says, meditation mediation shall proceed in advance of binding dispute resolution proceedings, which shall be stayed pending mediation for a period of 60 days from the date of filing. So on the day you file for, let's say, arbitration, you have 60 days to finish your mediation, okay? Unless you agree otherwise. Okay. 8.2.3. The parties shall share the mediator's fee and any filing fees equally. The mediation shall be held in the place where the project is located unless another location is mutually agreed upon. Agreements reached in mediation shall be enforceable as settlement agreements in any court having jurisdiction thereof. So this is pretty straightforward. Wherever your project is, that's where you have your mediation, and the mediator fees are split in half. Okay. 8.2.4. If the parties do not resolve a dispute through mediation pursuant to the section 8.2, the method of binding dispute resolution shall be the following. Arbitration pursuant to section 8.3 of this agreement, litigation in a court of competent jurisdiction, or other. If the owner and architect do not select a method of binding dispute resolution, or do not subsequently agree in writing to a binding dispute resolution method other than litigation, the dispute will be resolved in a court of competent jurisdiction. So, certainly it's important to understand what arbitration is, what litigation is, and the difference between them. I think there is plenty of materials that covers that, but in a nutshell, essentially arbitration is a process where you have a group of professionals, and that group is fairly small to keep it quick, relatively quick. You can have like 3-5 people who are essentially deciding which party is correct. And these people are people with a lot of experience in construction. However, their law expertise, I'm not really sure that they are lawyers per se, but I do know that they are very experienced in construction, and they get to decide which party is right. And certainly there's going to be an odd number of these arbiters, so that the process and the final word is resolved. Litigation is a process that involves lawyers and certainly people with a lot of experience in construction, and it's usually portrayed as this lengthy, expensive process that doesn't really do much good to anyone other than the lawyers. And it's important to understand this gradation between mediation, arbitration, and litigation, because, for instance, with mediation, the two parties, they still can talk to each other, even though during the process of mediation, the mediator can talk and will talk to both parties separately. But during mediation, they are still sort of friends that are having a serious tiff, let's say it like that. Arbitration is getting a little more serious, especially if it's binding, and it usually is. And then in litigation, like, you hate each other's guts, and that's really portrayed as a nasty process. And then the last bit of this paragraph says that if you as an architect and the owner do not check a box here, litigation will be the process that will be automatically chosen for you. 8.3 Arbitration. 8.3.1 If the parties have selected arbitration as the method for binding dispute resolution in this agreement, any claim, dispute, or other matter in question arising out of or related to this agreement subject to but not resolved by mediation shall be subject to arbitration, which, unless the parties mutually agree otherwise, shall be administered by the American Arbitration Association in accordance with its construction industry arbitration rules in effect on the date of this agreement. A demand for arbitration shall be made in writing, delivered to the other party to this agreement, and filed with the person or entity administrating the arbitration. Pretty straightforward. 8.3.1.1 A demand for arbitration shall be made no earlier than concurrently with the filing of a request for mediation. We said this already. But in no event shall it be made after the date when the institution of legal or equitable proceedings based on the claim, dispute, or other matter in question would be barred by the applicable statute of limitations. For statute of limitations purposes, receipt of a written demand for arbitration by the person or entity administrating the arbitration shall constitute the institution of legal or equitable proceedings based on the claim, dispute, or other matter in question. So this paragraph is saying that you can't apply for arbitration before you apply for mediation. I use word apply, but file. So that's the soonest deadline. The latest deadline is comes from the statute of limitations, and you should know the difference between statute of limitations and statute of repose and the differences between them. Essentially, statute of repose is a certain amount of time, it depends on the state, within which you can, starting from the substantial completion date, within this period, you can file for arbitration or claim. And statute of limitations is a window of time starting from the date when you discovered that you need to file a claim. And the size of these window time frames depend on the state. Some state will have just statute of repose, some will say statute of limitations, so pay attention to that. Is there anything else to say about that right now? I don't think so. 8.3.2. The foregoing agreement to arbitrate and other agreements to arbitrate with an additional person or entity duly consented to by parties of this agreement shall be specifically enforceable in accordance with applicable law in any court having jurisdiction of. So you can't really put some rando there on the board. 8.3, or your mom or grandma. 8.3.3. The award rendered by the arbitrators shall be final, and judgment may be entered upon it in accordance with applicable law in any court having jurisdiction thereof. So, what you get is what you get. Okay, 8.3.4. Consolidation or joinder. 8.3.4.1. Either party, at its sole discretion, may consolidate an arbitration conducted under this agreement with any other arbitration to which it is a party, provided that 1. The arbitration agreement governing the other arbitration permits consolidation. 2. The arbitrations to be consolidated substantially involve common questions of law or fact. And 3. The arbitrations may employ materially similar procedural rules and methods for selecting arbitrators. So this paragraph is telling you that you can have multiple arbitration processes and you can join them all into one if you satisfy these conditions. 8.3.4.2. Either party, at its sole discretion, may include by joinder persons or entities substantially involved in a common question of law or fact whose presence is required if complete relief is to be accorded in arbitration, provided that the party sought to be joined consents in writing to such joinder. Consent to arbitration involving an additional person or entity shall not constitute consent to arbitration of any claim, dispute, or other matter in question not described in the written consent. So there's a lot of kind of attorney lingo here, but what this essentially says is that if you are bringing a person on this joinder, they have to agree to that in writing. Okay. 8.3.4.3. The owner and architect grant to any person or entity made a party to an arbitration conducted under this section 8.3, whether by joinder or consolidation, the same rights of joinder and consolidation as the owner and architect under this agreement. So this joinder is a fair game. I mean, naturally, the fact that this occurs in this agreement says a lot about how the system has evolved, the system of resolving claims, because you can be an owner and you may need to resolve multiple claims. So the AIA allowing this kind of says a lot about what has happened in the past, because I mean, as I always say, whenever you're reading these paragraphs and articles, think about a situation or a scenario that triggered that sentence to appear here in the contract. So certainly your exam will not go into these super depths of arbitrations and these legal proceedings, but you certainly need to have a good grasp of what joinder is. It's not really a lot, but you need to know what it is. Okay, we have one more very short one. 8.4, the provisions of this Article 8 shall survive the termination of this agreement. Yeah, it's last but not least. So what this says is that this agreement can be terminated in the mid-construction or something. You can, you as the owner, you can terminate your contractual relationship with the architect at whichever point, essentially. But if you have a claim to make against that architect, this paragraph says that you can do it. And the other way around. Okay, moving on to Article 9, termination or suspension. So we were talking about claims and disputes. This is termination or suspension. So this part is talking about what happens when things go really, really wrong. So, okay, let's get to it. 9.1. If the owner fails to make payments to the architect in accordance with this agreement, such failure shall be considered substantial non-performance and cause for termination, or, at the architect's option, cause for suspension of performance of services under this agreement. If the architect elects to suspend services, the architect shall give 7 days written notice to the owner before suspending services. Remember this number. In the event of a suspension of services, the architect shall have no liability to the owner for delay or damage caused to the owner because of such suspension of services. Before resuming services, the owner shall pay the architect all sums due prior to suspension and any expenses incurred in the interruption and resumption of the architect's services. The architect's fees for the remaining services and the time schedule shall be equitably adjusted. So this is saying that if the owner doesn't pay you as an architect, you should give 7 days written notice to the owner saying, hey, you haven't paid me. If I don't get the money, in 7 days, I will be suspending my services. And when owner receives that email, or whichever way you're delivering that message, the owner can go like, oh crap, I'm going to pay the architect and make this go away. If the owner has no money and an architect stops delivering services, then that's it. Boom. But in case the owner wants to resume work and wants to have this architect continue their work, then the owner has to pay whatever the owner owed prior to suspension and all the other fees that incurred because the work was stopped. So yeah, that's that. 9.2. If the owner suspends the project, the architect shall be compensated for services performed prior to notice of such suspension. We just said this. When the project is resumed, the architect shall be compensated for expenses incurred in the interruption and resumption of the architect's services. The architect's fees for the remaining services and the time schedules shall be equitably adjusted. So it's a bit of a repetition from the previous paragraph, but one thing that is important to emphasize that I haven't said yet is that you can't blame, you as an owner, you can't blame the architect if your schedule slips, which makes sense. But again, because we said it already, this sentence happens to show up here in the agreement because some owner was oblivious to the fact that if the architect doesn't work on your project because you haven't paid them, you shouldn't complain about your time schedule. Okay, 9.3. If the owner suspends the project for more than 90 cumulative days for reasons other than the fault of the architect may terminate this agreement by giving not less than 7 days written notice. So, one thing that I maybe have mentioned before, but I'm not sure, when you see these days, they mean business days. It doesn't mean calendar days unless noted otherwise. So this short paragraph says, yeah, if the work is off for more than 90 cumulative days, cumulative means one after another. Oh wait, no. Yeah, no, it means like over the span of the work, 90 cumulative days. So it could be like work on and off, but in total, if you have 90 days, then of not working, then you should give your 7 days written notice. Okay. 9.4. Either party may terminate this agreement upon not less than 7 days written notice should the other party fail substantially to perform in accordance with the terms of this agreement through no fault of the party initiating the termination. 7 days. Remember that. 9.5. The owner may terminate this agreement upon not less than 7 days written notice to the architect for the owner's convenience and without cause. So, owner can terminate this agreement on a whim, essentially. 9.6. If the owner terminates this agreement for its convenience pursuant to Section 9.5, or the architect terminates this agreement pursuant to Section 9.3, the owner shall compensate the architect for services performed prior to termination, reimbursable expenses incurred, and costs attributable to termination, including the costs attributable to the architect's termination of consultant agreements. So, termination for the owner can be costly because then they have to pay for a lot of things, including architect's termination of consultant agreements, which makes sense because if I'm the architect and I'm already paying some people and I expect you to pay me so I can pay them, then if you terminate this agreement with me, then I will expect you to pay for my termination fees with my consultants. 9.7. In addition to any amounts paid under Section 9.6, if the owner terminates this agreement for its convenience pursuant to Section 9.5, or the architect terminates this agreement pursuant to Section 9.3, the owner shall pay to the architect the following fees. Set forth below the amount of any termination or licensing fee, or the method of determining any termination or licensing fee. Point 1, termination fee. So you can just put a lump sum of money or a percentage or something. Point 2, licensing fee if the owner intends to continue using the architect's instruments of service. So yeah, just put a number. 9.8. Except as otherwise expressly provided herein, this agreement shall terminate 1 year from the date of substantial completion. This is also a good thing to remember. 9.9. The owner's rights to use the architect's instrument of service in the event of a termination of this agreement are set forth in Article 7 and Section 9.7. I think that concludes our Article 9. Termination or suspension are certainly unpleasant situations, but there are a couple of things good to remember here. Not very difficult, so 7 days 90 cumulative days, and these termination fees, licensing fee, and then this paragraph 9.8, except as otherwise expressly provided herein, this agreement shall terminate 1 year from the date of substantial completion. Okay. Then last article in this video is going to be Article 10, Miscellaneous Provisions. 10.1. This agreement shall be governed by the law of the place where the project is located, excluding that jurisdiction's choice of law rules. If the parties have selected arbitration as the method of binding dispute resolution, the Federal Arbitration Act shall govern Section 8.3. So, if you have a project in Pennsylvania, your law is going to be from Pennsylvania, right? You can have an office, and the owner can be from Nebraska, let's say. But if the project is located in Pennsylvania, then laws of Pennsylvania will be applied. Okay. 10.2. Terms in this agreement shall have the same meaning as those in AIA document A201 2017 General Conditions of the Contract for Construction. So this is another contract that is the holy scripture of these proprietary exams, just like B101. And this paragraph is kind of telling me that at some point there was some sort of discrepancy between the meanings of terms in these two important contracts. And in this paragraph, AIA is kind of protecting themselves by saying they all mean the same. Okay, 10.3. The owner and architect respectively bind themselves, their agents, successors, assigns, and legal representatives to this agreement. Neither the owner nor the architect shall assign this agreement without the written consent of the other, except that the owner may assign this agreement to a lender providing finances for the project if the lender agrees to assume the owner's rights and obligations under this agreement, including any payments due to the architect by the owner prior to the assignment. So if you, as the owner, want to hand this agreement to someone else to take your duties, you can only do that if they consent, if they give you a consent and sign. Okay, 10.4. If the owner requests the architect to execute certificates, the proposed language of such certificates shall be submitted to the architect for review at least 14 days prior to the requested dates of execution. If the owner requests the architect to execute consents reasonably required to facilitate assignments to a lender, the architect shall execute all such consents that are consistent with the agreement, provided the proposed consent is submitted to the architect for review at least 14 days prior to execution. The architect shall not be required to execute certificates or consents that would require knowledge, services, or responsibilities beyond the scope of this agreement. So this is saying if you're the owner and you need the architect to approve a certificate, execute a certificate, you will see certificates of payments. You need to allow the architect to review those certificates for at least 14 days before you want them confirmed and executed. This last sentence is interesting. It says, the architect shall not be required to execute certificates or consents that would require knowledge, services, or responsibilities beyond the scope of this agreement. So, again, kind of curbing the responsibility away from the architect. But it makes sense because if you sign something that you're not sure of, you're just putting yourself in a really dodgy situation. And this contract sort of protects the architect from that. nor should the owner or anyone else be pushing the architect to execute something that they don't feel comfortable doing. 10.5. Nothing contained in this agreement shall create a contractual relationship with or a cause of action in favor of a third party against either the owner or architect. So, yeah, let's say my mom signed this contract as an owner and she died 2 months in, and I cannot just really assume a contractual relationship with the architect unless I have something signed with mom. Nor can architect go after me just because I'm the owner's daughter to fulfill their duties. This example is kind of gloomy, but yeah. 10.6. Unless otherwise required in this agreement, the architect shall have no responsibility for the discovery, presence, handling, removal, or disposal of, or exposure of persons to hazardous materials of toxic substances in any form at the project site. So in, I think, A201, you will see that what I just read here is contractor's responsibility. 10.7. The architect shall have the right to include photographic or artistic representation of the design of the project among the architect's promotional and professional materials. The architect shall be given reasonable access to the completed project to make such representations. However, the architect's materials shall not include the owner's confidential or proprietary information if the owner has previously advised the architect in writing of the specific information considered by the owner to be confidential or proprietary. The owner shall provide professional credit for the architect in the owner's promotional materials for the project. This section 10.7 shall survive the termination of this agreement unless the owner terminates this agreement for a cause pursuant to section 9.4 and 9.4 was if the architect essentially fails to perform. So this 10.7 paragraph is saying that architect should be able to promote the project unless the owner specifically says, no, this is very confidential to me, or if, I don't know, you're doing some kind of secret military base, and it can be the best military base in the world, but if the government says, no, we don't want anyone to know about this, the fuck, you can't really advertise it. And also, this paragraph says that the owner shall provide professional credit for the architect in the owner's promotional materials for the project. So they kind of mutually respect each other in the Department of Marketing. Okay. 10.8. If the architect or owner receives information specifically designated as confidential or business proprietary, the receiving party shall keep such information strictly confidential and shall not disclose it to any other person except as set forth in section 10.8.1. In this section, 10.8 shall survive the termination of this agreement. So, if someone tells you something confidential, don't spread it. It's kind of like in school or at work. Just don't gossip. 10.8.1. The receiving party may disclose confidential or business proprietary information after 7 days notice to the other party. So it means like I tell you, hey, this is confidential, and then you tell me, well, I'm going to disclose it in 7 days. So that at least they're kind of prepared for the hit. Notice to the other party when required by law, arbitrator's order, or a court order, including a subpoena or other form of compulsory legal proceedings issued by a court or a governmental entity, or to the extent such information is reasonably necessary for the receiving party to defend itself in any dispute. So you can disclose this information only if you're forced by a court or a governmental entity, or to defend yourself. The receiving party may also disclose such information to its employees, consultants, and contractors in order to perform services or work solely and exclusively for the project, provided those employees, consultants, and contractors are subject to the restrictions on the disclosure and use of such information as set forth in Section 10.8. 10.9. The invalidity of any provision of the agreement shall not invalidate the agreement or its remaining provisions. If it is determined that any provision of the agreement violates any law or is otherwise invalid or unforeseeable, then that provision shall be revised to the extent necessary to make that provision legal and enforceable. In such case, the agreement shall be construed to the fullest extent permitted by law to give effect to the parties' intentions and purposes in executing this agreement. So it says that just because you and the owner agree that a piece of this agreement is invalid, that does not invalidate other provisions. And that brings us to the end of Article 10. This article was a little bit of a mixed bag. There is a little bit of everything there. Things that are good to know. But I think it's not so hard. We're going to move on to Article 11, Compensation, in our next video. Bye!